Hi, I'm Jonathan Harr, and welcome to Law and Film, a podcast that explores the rich connections between law and film. Law is critical to many films. Film, in turn, tells us a lot about the law. In each episode, we'll examine a film that's noteworthy from a legal perspective. What legal issues does the film explore? What does it get right about the law, and what does it get wrong? And what does the film teach us about the law and about the larger social and cultural context in which it operates? Our film today is a civil action, the 1998 movie based on Jonathan Harr's critically acclaimed book of the same name. Written and directed by Steve Zaillian, the film stars John Travolta and features supporting performances by Robert Duvall, who was nominated for an Oscar, William H. Macy, James Gandolfini, John Lithgow, Kathleen Quinlan, and Tony Shalhoub. The film tells the true story of a court battle over the environmental pollution in Woburn, Massachusetts in the 1970s and 1980s, where chemicals like trichloroethylene, or TCE, an industrial solvent used in several industrial operations, contaminated the local water supply, leading to numerous fatal cases of leukemia and a cancer cluster. The victims included a number of small children, as well as many other health problems for Woburn residents. Boston personal injury lawyer Jan Schlichtmann and his small firm brought suit on behalf of a group of victims' families against two large corporations, Beatrice Foods and W.R. Grace. There was a third company that previously settled. The families demanded compensation and justice for the horrific tragedy, but their quest for compensation and justice ran into dogged resistance from the large and powerful law firms on the other side, especially prominent WilmerHale, then Hale and Dorr partner, Jerome or Jerry Facher, played by Robert Duvall. The economic toll of the litigation eventually drove Schlichtmann and his firm to bankruptcy. The film offers a dark view of the U.S. legal system and why it often seems ill-equipped to uncover the truth and provide accountability and justice for victims. Joining us for a discussion of a civil action is Jen Corinis. Jen is a graduate of Wellesley College and a graduate in 2000 of Boston University School of Law. She was in private practice until 2007 in Boston and then moved to Tampa, Florida, where she worked from 2007 to 2021 for the U.S. Attorney's Office there. For much of the time, Jen was a trial attorney in the U.S. Attorney's Office defending various federal agencies and litigating complex tort cases and other civil litigation and engaged in numerous federal trials. She also worked in the appellate division where she argued civil and criminal appeals before the 11th Circuit Court of Appeals. She also served as a senior litigation counsel and was responsible for training assistant U.S. attorneys. While at the U.S. Attorney's Office, Jen co-founded a mentoring program with another assistant U.S. attorney, Lindsay Griffin, at a Title I elementary school, and she was awarded the U.S. Attorney General's Volunteer Award for Community Service and the Hillsborough County Public School Partners in Education Award, both in 2017. After leaving the U.S. Attorney's Office in 2021, Jen returned to private practice and now serves as of counsel at Greenberg Traurig in its Tampa office, where she's part of the Labor and Employment Group and continues to practice civil litigation. Jen leads the Tampa office pro bono program, where she focuses on immigration cases. She serves on the boards of Gulf Coast Legal Services and the Tampa Museum of Art. One other important detail from Jen's bio is that from 2000 to 2001, she served as a clerk for U.S. Court of Appeals Judge Sandra L. Lynch in the First Circuit, where I was fortunate to also serve that year as a clerk for Judge Lynch. So Jen and I were co-clerks for the judge during that year. We got to know each other very well and worked for a truly fantastic judge in the First Circuit deciding important cases. So it's really great to reconnect with Jen after such a long time. And what better way to do that than to talk about this seminal movie about American law, A Civil Action. Welcome, Jen.
Thank you so much. It's so great to talk to you again after all this time. After just a few minutes, it feels like we're back in the library in Judge Lynch's chambers having lunch and talking about appeals. And I agree with your assessment that Judge Lynch was and is a fantastic judge. And despite the fun I had at the U.S. Attorney's Office, it still is the best legal job I'd ever had.
Truly an amazing experience. Since I clerked in the district court as well and had my former judge, Judge Rakoff, on, I will make clear to say that they were equally the two of the best experiences.
That's very fair. I totally understand that.
Partiality is key. So
yes, it is.
The Civil Action, the movie, the 1998 movie, which was based on the 1995 book, it's a fantastic book and I think also a very good movie. The first thing we were assigned in law school was the book, A Civil Action, to kind of give you a maybe a more nuanced view of the legal profession. But let's start here. Can you talk a little bit about the larger context for the lawsuit that's at the center of a civil action?
What I really take away from the book and the movie is the uncomfortable question of whether our legal system is the right place to vindicate these kinds of cases. Is this the right forum in which to remedy the loss of a child due to allegedly somebody's negligence of dumping these chemicals? And it also is a pretty unpleasant look in some cases of the legal profession and the lawyers themselves. So to me, the larger context is very probing and sometimes unpleasant look at the personal injury legal system, the court system, jury system, all of that. And I really don't think that either the plaintiff's lawyer, Jan Schlichtmann, or Jerome Facher, or William Cheeseman, any of them really is a villain or a hero, or wears the white hat or the black hat. In a movie, we want a hero in the end. And the message I take away from this movie is that there really isn't one. And nevertheless, there are still these children and these families that are devastated, and they feel deeply unsatisfied with the outcome.
And the film, interestingly, in terms of character development, I think the main focus is on the protagonist, Jan Schlichtmann, the lawyer,
Right,
who takes up the case of the families who were the victims of the pollution in Woburn. And he starts out as sort of a hard-edged, successful personal injury lawyer, very focused on the bottom line. Sort of his view is that all the legal system can provide is money. And his goal is to get as much money for his clients and, well, as well, since he works on a contingency basis for himself and his partners. And part of the, it's interesting in the film is to watch him transform, become obsessed by this case. That's where maybe he loses his way when he starts to think the legal system can deliver more than dollars and cents. But
right.
let's start at the beginning. The film opens with what seems like sort of straightforward medical malpractice suit against Mass General Hospital. A horrific outcome. The victim is in a wheelchair, but it doesn't seem particularly complicated from a legal perspective. That's the sense the movie gives us. And so what we see is we see Schlichtmann taking his wheelchair-bound client from the hospital to court where trial is set to begin. And we hear a voiceover of Schlichtmann describing how cases are valued or not valued by the legal system. And then it's almost like a race against time for the defense to make a good enough offer before Schlichtmann opens. But let me play this clip about how the legal system assesses value.
It's like this. A dead plaintiff is rarely worth as much as a living, severely maimed plaintiff. However, if it's a long, agonizing death, as opposed to a quick drowning or car wreck, the value can rise considerably. A dead adult in his 20s is generally worth less than one who is middle-aged. A dead woman less than a dead man. A single adult less than one who's married. Black less than white. Poor less than rich. The perfect victim is a white male professional, 40 years old, at the height of his earning power, struck down in his prime. And the most imperfect? Well, in the calculus of personal injury law, a dead child is worth the least of all.
What's your impression here in terms of Schlichtmann's view of the legal system and also who makes a good, better, or worse point?
I mean, it is kind of an ugly, it's not kind of, it's an ugly and cynical way at the outset to start off, and it's sort of jarring, and that's on purpose because he really isn't wrong. And I defended VA hospitals and community health centers in some truly horrific cases. And in those cases, we had no choice. And Schlichtmann is correct. The only way to resolve those cases is with money. And in order to do that, you have to assess what is the loss. So he puts it in somewhat crude terms, but it is true. What is the loss? And if you have someone who's in the prime of his or her life, married with a good job, that is going to be a victim whose life is valued more. It's just a fact because the loss of income, the loss of consortium, and things like that. And so there were times that I remember lawyers getting somewhat squeamish about, oh my God, you're trying to put a dollar amount on the life of a child. They said, well, you did that when you filed this lawsuit. That's all we can do. We have to do that. So let's do it somewhat dispassionately. And that's really the way you serve your client best. It's not that there isn't that part of you that thinks this is really a tragedy. It's awful. There's no amount of money. But you have a job to do, and the job is either recover compensation for your client, like Schlichtmann is, or to make sure that if your client did something wrong, that they compensate the victim fairly, but that they're not taken advantage of. So it is fair to say, as he says, the perfect victim is what I just described, someone who's in the prime of his or her life with children and earning, whereas a child, unfortunately, they don't have that earning potential that's demonstrated, and they have the loss consortium with their family, but the compensation is not going to be as much for that as it would be for someone like the victim that Schlichtmann brings into the courtroom. And I mean, it's a movie, so it's somewhat cartoonish. You know, he's dabbing in his mouth, and the jurors are already openly weeping. And, you know, it's a bit much. But the one thing I take issue with is, as a defense lawyer, is when the lawyer on the other side is scribbling numbers on the Post-it note and holding it up, desperately trying to keep Schlichtmann from doing his opening statement, because then he knows the value goes up. And then he, you know, Schlichtmann rejects the 1.5, and then he writes 2 million, please. And Schlichtmann gives this nod, and then it's over. And I can tell you that if I had said please, the lawyer like Schlichtmann would have correctly assumed that I had more money. You do not say please, you say, oh God, you're killing me. The most I'm ever going to be able to get you is 2 million. Don't make me go back. That is absolutely it. You don't say 2 million, please.
It's last and final offer, not last and final offer, please, right?
Exactly. So again, it is a cynical view, and it's put somewhat crudely by Schlichtmann's character, but it's not wrong.
Is there a difference, as I'm thinking about this in the film, between something that's a more straight med mal case involving negligence, and then something where we'll get to when we talk about the pollution in Woburn, where the primary victims are children, the ones who died of leukemia, for example, the daughter of the named plaintiff, Ann Anderson, because there's another element of damages, right? There's compensatory damages. I think that's what Schlichtmann is talking about.
Correct.
In terms of children being the least desirable victims from a compensatory damage perspective. But there's also punitive damages, right? So that maybe is another consideration that enters into the equation.
And that's a huge consideration here, obviously, because, and that's why, as we'll talk about later, Schlichtmann is focusing on their yearly earnings, because punitive damages are intended to be relative to the bad actor, and they're supposed to hurt. So absolutely, punitive damages are a way to be sort of that private attorney general and punish a wrongdoer by imposing punitive damages on them. And I think that that's what some people misunderstand. When you see a verdict in a case where, it seems like, okay, it's a sad case, something terrible happened, but the plaintiff recovers, $50 million, and it seems wildly disproportionate to what was needed to compensate the victim, that will often be because there are punitive damages. And as the name suggests, it's intended to punish. So yeah, that is definitely an element here that's not really talked about in the case.
Going back to Schlichtmann, after this opening scene where he finagles and negotiates this lucrative settlement from Mass General, it cuts to Schlichtmann and his success. He's on the cover of
Boston Magazine,
Boston Magazine, right? As the most eligible bachelor. He's drives a fancy car. He's got a very big closet full of very expensive suits. He's sort of at the top of his game, right? And there's no stopping him. And then, he gets this call from the group of plaintiffs in Woburn, Massachusetts, that he's been promising to go see regarding the industrial pollution there. It's a very sad case. Everyone sees that, but it's described as an orphan, a case that no one seems to want to take because it seems too challenging for various reasons, which we'll get into, despite the harm, the magnitude of the tort. And so Schlichtmann says, all right, I'll go. He drives out, sees the family, hears from the family, and certainly I think he's upset, but he's not moved yet. And then on his way back, as the movie describes, he gets his second speeding ticket. He got one there, and he stopped near an area where some of the contamination was said to occur, and he observes what he thinks is evidence of at least one of the companies that they have been contaminating the water supply. So basically, Schlichtmann learns that there's actual evidence that the companies were involved, and presumably he thinks they're good because they've got both Beatrice Foods and W.R. Grace have deep pockets. So he thinks this is a good case from a financial perspective. But his accountant, played by William H. Macy, says, don't take this case from a financial standpoint. It's not a sound investment. Why is the calculus different here for a case like this involving environmental pollution from a med mal case or other garden variety tort cases that provides the bulk of the firm's docket?
In a tort case, those are a lot of the ones that I handled. If the case goes to trial, I think it's accessible for a jury to think this person went in for an operation. They came out of the operation with an injury. And then you have an expert explaining that the doctor made a mistake and that's why this person is injured. People can understand that. Or that, I saw a car run a red light, it hit this person, and it caused them injury. Those are obviously simplified versions, but I think that's accessible to a jury. They can understand that you're going to have experts and they're going to have the battle of the experts, but it's going to be a lot more easily comprehensible by a jury. Whereas these environmental cases are usually extremely long. They involve, as is the case here, extremely complicated expert testimony involving, water tables and geology and things that are not in the everyday experience of a juror. And again, going back to my initial point, that this really isn't the best form to do this. You've got this artificial layer of the jury can't ask the experts questions. They can't, as is the case today, go on Google and try to figure it out for themselves. They just have to listen to, in this case, literally months of expert testimony about this very esoteric science that is not something they have any experience with. So the calculus is totally different. On the other hand, it is children. They're very compelling victims. And so from a punitive standpoint, it is a very, very compelling case. But you're right that Schlichtmann initially, he has those two sides of himself that eventually become blurred, I think, where he has the calculus of, is this something that I can get paid to do and prove and get what the client wants, versus this is something really sad, that those two eventually become blurred. And in the beginning, he also does a lot of the voiceover of trials are a corruption of the process, and only a fool with something to prove ends up ensnared in it. And by something to prove, I mean about themselves. And it's funny that he says that at the outset, because that is a very apt description of what happens to him eventually, is he is just no holds barred, going to go to trial. The whole corruption of the process, if you don't settle, it goes by the wayside, because not only is it these children, but he sees these corporations as callous and he wants to punish them.
I think you hit the nail on the head. I mean, he goes from the ultimate rational actor calculating everything in terms of what it's going to deliver monetarily, which in a way is serving his clients, to being kind of taken by the story and the larger struggle and becomes on kind of a man with a mission and loses sight of these things. Yeah, just to follow up on your point about the challenges of mass tort cases like environmental harm, environmental pollution, I guess another aspect is they also often involve, as they do here, large corporations, which may have deep pockets, but also because they have deep pockets, they can spend a lot of money on litigation.
Right.
Schlichtmann is a small firm and he's up against big law in this case.
Yes. And that is obviously a huge thumb on the scale. And that comes later on in the film when he goes up to meet with the representative of W.R. Grace. And he's talking about how, we can afford to pay a lot more than this. And of course they can. And they have the wherewithal to keep going and keep defending this case and just bleed him dry. And they also, and a big corporation like that also says accurately, we can't just throw money at you as much as you demand, because we're just going to have a line out the door of people filing lawsuits against us if they learn that you stick around long enough, you're going to get a huge check. So he's got that balance. But yeah, for sure, that Hale and Dorr and all these other large law firms, they have those resources. They've got a ton of associates. They can just keep going for years. And at some point, I think Facher mentions that he's aware that the IRS has a lien on any settlement. So he's not even hiding the fact that he knows what that pressure is for Jan, and he's going to press on it.
It's real tactical warfare. That scene between Schlichtmann after the case kind of starts falling apart and the head of W.R. Grace, Al Eustace, who's played by Sidney Pollack, where after he sort of strings him out with a long lunch at the Harvard Club where you're not supposed to discuss settlement. I have no idea if that's true. Yeah, it's a great scene. I should add, because we talked about Michael Clayton in an earlier podcast, and Sidney Pollack there is playing the very hard managing partner, Marty Bach, in that case. Sidney Pollack seems to love playing this very hard-edged captain of industry, kind of master of realpolitik. So it's another great role for him. So going back to the firms, the way it's set up, there's three main lawyers. You've got Schlichtmann representing the plaintiffs, and then you've got the two lawyers representing the companies. Jerry Facher represents Beatrice Foods. He's from WilmerHale, the Hale and Dorr. And then you've got William Cheeseman, who's the lawyer representing W.R. Grace and Company. But it's really set up in a way, this clash between Schlichtmann and Jerry Facher, who's a legendary litigator, recently passed away, I believe, from what's now WilmerHale, who represents Beatrice Foods, one of the two large companies that Schlichtmann sues. Now, Beatrice, they're involved because they got stuck, it looks like. I mean, they had bought Riley Tannery, this family-owned business, which was, I think, a pretty decent size, which had dumped the toxins, contaminating the drinking water. They bought it in 1978, and then they sold the company back to Riley in 1983, but they maintained legal liability. Can you talk a little bit about the different approaches of Schlichtmann and Facher to litigation?
So Facher's approach is diametrically opposed really to Schlichtmann's, and he appears to be very sober, very calm, always kind of in the background. He doesn't miss anything. He is always calculating. He's a brilliant guy, and he was known around Boston legal circles as the Dark Prince, which is not to say he's a bad person. He's just a very, very formidable lawyer. And like you, in my class in law school, my first year civil procedure class, our professor, who I'm going to give a shout out to, Professor Ward Farnsworth, it was his first year teaching, and he also used a civil action as a teaching tool. And because we were in Boston, he had a research assistant go to the courthouse and get all of the documents from the court case, which, back in the olden days, you went and got the actual paper and brought it. And so we used those in class. It was really interesting. And near the end of class, he even asked, and Jerry Facher agreed, to come to our class to talk to us at the end of the year. And it was absolutely fascinating. And I will say that I don't know the other characters involved very well, but Robert Duvall nails it. Jerry Facher really was like that. He came into the classroom and had sort of, I'm a simple country lawyer. Oh gosh, it's so sad. But water doesn't, it's gravity. And, he's sort of making marks on the blackboard and holding out his hands as though we're all so distressed about this. And again, I'm not saying he's a bad guy at all, but he's just a very formidable lawyer. So his approach is he is always calculating. He's always several steps ahead. And then Schlichtmann, he kind of has one speed. He's very mercurial. He's got a ton of energy. And so he's running around in circles, and Facher just standing there, kind of half smile on his face, and throws out a couple of chestnuts while Schlichtmann is running around and getting emotional. So they're very, very different. And I'm not disparaging Schlichtmann at all. He was very successful, and by all accounts was and is a really good lawyer, despite having somewhat lost his way in this case. A very good lawyer is a really different approach. I've seen both. And both can be effective in their own way. Both are very effective in front of a jury. Schlichtmann's very emotional, probably very relatable. And Facher is just, like I said, brilliant. I mean, he's in the court during the Rule 11 hearing, and he appears to be focusing on taping his litigation bag, because he carries the same bag all the time. He's always taping the handles and stuff. There's no way he's missing anything. He knows exactly what's going on the whole time.
The bag's a great detail. I don't know if he brought it to class, but it's another contrast between him and Schlichtmann. He's got this old briefcase, refuses to give it up. Obviously, he can afford whatever he wants. And Schlichtmann has the fancy car, dozens of fancy suits. So very different approach. And Schlichtmann's, I think, worked very well in the more simple, straightforward type of cases, like they started at the beginning with the medical malpractice, but different in this very legally and factually complex federal litigation. He's a great character in the movie. I didn't have to know him, never met him, but great character. And Robert Duvall's performance is certainly phenomenal. So talk about the other lawyer, William Cheeseman. There's a moment in the film early on, and you mentioned this when you referenced Rule 11. Cheeseman, who's representing W.R. Grayson Company, the other defendant, wants to file a motion for Rule 11 sanctions against Schlichtmann. Facher refuses to join. What's Rule 11 and what's going on with that scene?
Well, first of all, I mean, that's accurate. Cheeseman gets the, and by the way, it is Cheeseman and not Cheeseman, as they say in the film. I think that's kind of gratuitous. They don't need to do that. But anyway, so Cheeseman gets the complaint, looks at it, and calls Facher, who's methodically tossing a ball against the wall while he talks to him. Again, that sort of cultivated air of I'm just casual here. And Cheeseman wants to file this Rule 11 motion, which is a motion that says lawyers have to have a reasonable basis for anything they put their name on, including filing a lawsuit, you've done a reasonable investigation, and you have evidence, or you likely will have evidence. So Cheeseman looks at this and thinks that Schlichtmann is vulnerable there and that he might be able to kill this thing in the cradle, whereas Facher knows correctly that it's very unlikely that that's going to work. It's not an often used vehicle for this type of thing, and most likely it's going to result in the judge dismissing it without prejudice and telling Schlichtmann to try again, which would be what happened if you filed a Rule 8 motion for a more definite statement. But instead, Cheeseman takes this very heavy instrument of Rule 11 to try to get it knocked out in the beginning. And Facher makes the point of, if you're going to knock someone down, do it so they can't get back up. And Cheeseman learns very quickly that he didn't do that, and that's why Facher didn't join. And when they go into court, the judge even says, to Schlichtmann, Mr. Schlichtmann, do you know what Rule 11 is? And he says, no, I had to look it up. And the judge says, so did I. I mean, we all kind of know what it means, but to actually look it up to see it as a basis of a motion for sanctions, and that sanction being toss the case, is very unusual. To have a judge say, on the face of this complaint, I am making a conclusion that this was in bad faith. You didn't have a reasonable basis. There's no evidence here. So it was probably not the right move. And Facher recognized that. And I think when Facher said, this is not my motion, this is Hoag's motion, she's going to immediately loses credibility with the court, because the court knows Facher. It makes it very clear that he knows Jerry Facher, asks about the Red Sox. And I'm sure practitioners have probably had that experience. I have had that experience where your heart kind of sinks when the judge has that familiarity with one of your opponents. And you think, oh gosh, judges are impartial, but that other lawyer has some credibility and familiarity with the judge. And that's exactly what happened here. And in the book, it gets much more into this. And there is also this very arcane charge of barratry, which is when a lawyer basically gins up a case in order to create a business opportunity. So they gin up a conflict between other people. But it was very complicated and arcane stuff. And Schlichtmann was really indignant that this was brought. And so he's protesting and hopping up, just outraged that this has happened. And it's a very interesting little window into something that might otherwise be boring, but in this case, it's actually pretty interesting.
I mean, it's very rarely used, Rule 11. If you're going to file a Rule 11 motion, it's pretty significant. It's quite a step that he takes. And as you said, I think it's interesting and revealing that Facher doesn't join. In a sense, it seriously undercuts the credibility before the judge, given Facher's reputation. The strategy that's attributed to Facher in the movie is to try to persuade the judge, Walter J. Skinner, the district court judge, to bifurcate the trial into two phases. First phase will be liability. Did the companies, were they responsible for contaminating the water, and did it cause the damages? And then the second phase would be the damages phase, which is what was the injury, how bad was it, all the things that would go into the actual calculation of the award. So the first phase liability, second phase damages, and under Rule 42 for bifurcation, you would only get to damages if you show liability. I'll play a clip here of Facher talking about bifurcation, the strategy.
Jan, have a seat. You want something to drink? Some coffee, soda? You've been talking without my being present? No, we have been drinking coffee without your being present. Don't be so paranoid. We're early. All right, what's up, Jerry? Last night, I was at a ball game. It was the 7th-inning stretch. And I was standing there, and I don't know why, but it occurred to me at that moment, unless you've proven that any, what word should we use? Chemicals? Poisons. All right, if you like that word, I'll use it. Unless you've proven that any poisons actually reach the wells, there's no case. And therefore, no need to make these families who've already suffered so much relive this suffering all over again by putting them on the stand. Your Honor, you've got... That's interesting. I think I'd have to agree with that. Well, Your Honor... Yes. If the jury decides favorably on the geological evidence, yes, then you could bring your families in. Your Honor, the jury came into this courtroom expecting a human drama. And instead, for 3 months, we've been giving them lessons in geology. Now, we had to do that, but now it's over, finally. Now it's time. Now we have to see where we are before we can move on, and before we subject these families to more trauma than is necessary, because that would just be cruel. Well, they want to testify. Mr. Schlichtmann. They need to testify. The decision has been... Well, this is the defendant's plan. No, it's my plan. This is Facher's plan right from the beginning. He told me, he threatened me. It's my plan!
So how does this strategy affect the case, and what did you make of the film's depiction of it?
It's a good strategy. It's not an uncommon strategy. They portray it, and again, it's fine. It's entertainment. It's a movie. Portray it as something sort of shocking that Schlichtmann doesn't see coming. It's really not that unusual in a big case like this. Schlichtmann probably had not encountered it in his cases, to be fair. But when you've got a big case with lots of parties and very complicated scientific evidence like this, it actually does make sense for a lot of reasons, judicial economy, to get that out of the way first, because if you can't prove causation, if you can't prove the car went through the light and hit the car, what's the point of talking about the tragedy that befell these families and the children who died and their suffering? So it's not really an unusual strategy, but it makes a lot of sense. And Facher very early on says these families can never testify, he says to a colleague. And that's because he knows not only is it judicial economy to make sense to establish liability first. He also knows, he wagers, and I think correctly so, that having families get up there and talking about these tragedies and their children who died and the suffering they went through, it can color a jury's interpretation of evidence. And it may, without them realizing it, make them more likely to find causation, to find liability on behalf of the company, because now you've got this terrible thing has happened and these companies are accused of causing this tragedy by dumping chemicals. And this awful thing happened. And so the very technical questions about whether the chemicals seeped into the groundwater and whether they actually cause leukemia become somewhat academic if you've got all of that out there beforehand. So Facher's strategy is not uncommon, and it is a wise one. The way that it happens in Judge Skinner's chambers, I hope that's not accurate. I doubt it is accurate that there would be this ex parte meeting with the defendant's lawyers in Judge Skinner's chambers before Schlichtmann gets there. But Schlichtmann is correct to be upset that Facher has, suggested this strategy that Skinner embraces, Judge Skinner, excuse me. And then that leads then to these very complicated interrogatories that would be part of the first trial to find out whether or not there's liability.
The film portrays it as kind of this very innovative maneuver that's never been done. It is fairly common, especially in these cases, as you say, and you talk about some of the reasons. One of them is economize. The other you describe as prejudice, which is built into the standard itself, i.e. that hearing testimony from victims about harm could be prejudicial to the jury's determination if the plaintiff had not proven causation, that the defendants were responsible. The film a little bit makes it look like this kind of sneaky maneuver, but it's common and it is fair game under the federal rules of civil procedure.
There's no question that I'm sure Facher outflanked Schlichtmann on many occasions. This is probably not one of them. And it's also kind of gratuitous too in the movie. I really like the movie. I'm not bashing the movie, but it's funny that Facher is in Skinner's chambers. And again, he's sitting in the background on a couch, just drinking his tea absentmindedly. And then says, well, why would we put the families through that kind of trauma? And that's not why. And it's not his role to worry about that. I mean, that's true too, but that's not why he made this motion. That's not why he sought bifurcation. He sought bifurcation because it is the correct strategy in these circumstances.
Exactly. Something kind of walks in and just feels like he's sort of crashing a party almost. You do feel like Schlichtmann is kind of culturally a little bit of an outsider. You have the elite lawyers and then the judge coming from more elite circles, and Schlichtmann, from a cultural level, although he's very successful, is in a different class, so to speak.
And it's interesting that you point that out. I think some of that is a function of this case being removed to federal court. It started out in state court. Some of the cases that I had when I was at the U.S. Attorney's Office, I would encounter very talented, very good lawyers who always operated in the state system. And then when you sue the United States, you're in the federal court system. It is a very different atmosphere. So Schlichtmann is probably well known and used to operating in state court. And state court can kind of be the Wild West, and federal court to me is kind of like church. It's very different. And so I suspect that Schlichtmann and Facher, because they represent big companies, are in federal court very often, as other lawyers from these big firms are. Whereas someone like Schlichtmann is definitely out of his element. Not that he's not smart enough, but it's just not the setting that he is used to. So when he comes barreling in and he's popping up at the hearing and he's yelling at the judge for having this meeting without him, it is not really the type of lawyer that you usually see in federal court.
That's a great point. I mean, to put it in film's terms, this is in Fenway for Facher. Right? This is his home turf, and I think it would have been different. I don't think Facher or Schlichtmann would have been as successful if this had been in state court. I mean, I think they would have had a probably different array of lawyers. That would have been Yankee Stadium or something for Facher. Yes. He's in his element. It's much less like the emotional appeals, doing things on the fly and from your gut. Yeah. More in state court. Federal court is much more tactical warfare. It's much more motion, paper-based, and I think Facher and Schlichtmann are in their element, and Schlichtmann, while a very good lawyer, is not.
Just an anecdote on that, and if the lawyer about whom I am speaking hears this, he will know that I tell this story with great fondness for him. He's a friend. But we had a case in federal court, and it was a bench trial, and he was making an argument, and the judge's rule, as most of the federal judges, is, you stay behind the lectern. So he was so used to being effective and being in front of a jury and gesticulating and walking around that he found it really difficult to stay behind the lectern, and he would put his hand on the lectern and kind of circle it while still sort of touching it technically. And the judge would say, there's no jury here. There's no jury here. It's just me. And you could see that it was just painful for him. He wanted to be walking around and gesturing and pounding the lectern, and it just wasn't suitable for federal court.
One of the interesting things about Facher, I think, is his intuition that the jury would likely dismiss the case against his client, Beatrice Foods. And he says the reason that the jury will let the case go forward against the co-defendant, W.R. Grace, but not against Beatrice, is that there was witness testimony that the witnesses actually saw employees of the food packaging company, the subsidiary owned by W.R. Grace, dispose of TCE, the toxin, by dumping barrels and chemicals out back. So you had actual witnesses watching them basically dump the stuff out where it could get into the water. By contrast, the 15-acre property adjacent to and owned by Riley Tannery, which was the company that Beatrice Foods had responsibility for, was heavily contaminated. That area was contaminated. There was no actual eyewitness testimony that saw anyone from Riley dumping the contaminants onto the property. Now, you look at Riley in the movie and you're like, there's no way this guy didn't do it. But he's a nasty looking guy, right? There's no evidence. So it's an interesting and I think astute assessment, or it was a good guess. I mean, what did you think of that scene in the movie?
I thought that was a brilliant point by Facher, and maybe an educated guess, but probably a very shrewd calculation by him, because he knows how juries operate. And so if you have, again, going back to whether this is really the forum to vindicate these kinds of claims, you've got these experts, they all look really smart, really, convincing, and they're diametrically opposed. They completely disagree with each other. They're all cross-examined, and it's very difficult for a jury to figure out who is correct. They can't ask questions. They can't Google it. So they could go either way. But then you add on to that an actual person dumping these chemicals into the ground, then the jury really can latch onto that. That is going to be something that's more within the ken of the average juror to think this could be bad stuff and somebody actually was dumping this and they tried to conceal that they were doing that. So that is a very tangible proof that this big company dumped things. And I'm sure it was more complicated than that, but I totally agree with Facher where it's much more theoretical. They had the land for a few years and it's contaminated. We don't know how that happened. We don't know who did it. There's no eyewitness who can talk about how that happened. So he obviously wasn't guaranteed that, which is why he made that offer to Schlichtmann in the hallway. But he was absolutely right. And I think that was from his many years of experience of cases and dealing with juries.
On the expert testimony, the liability case, which is the focus of the trial and where things are decided, the liability phase, centers a lot on expert testimony. And there's a lot of testimony that's explored more, in the book and obviously in the court documents about whether or not you could prove that the chemicals went from Riley Tannery into the drinking water. And the plaintiffs relied a lot on a hydrological expert who critics have said sowed confusion and also undercut his own credibility about whether the toxins could have leaked into the drinking wells. There was an issue about, because there was a river between the tannery and the wells, whether you could have traced the chemicals to the wells as opposed to coming into the drinking water or the wells from somewhere else. What role does scientific evidence play in the case and more generally? And you can just talk a little bit about expert testimony.
So in a lot of the cases that I handled, I had to hire experts. The other side hired experts, and it can be very complicated, certainly not to the level here, but I'll just tell you what my approach was that was effective was to have an expert, and as brilliant as they were and as many articles they may have written about these very technical medical issues, they still had to tell a comprehensible story. And I don't mean they dumbed it down, but they still had to make sure that what they were conveying is something that would make sense and resonate with the jury or with the fact finder. And so you had to make sure the expert understood this is not for you to teach a class. This is for you to answer a very specific question and teach the fact finder. So we're not looking at all sides dispassionately. We're looking at this one question. And I think based on what I remember from the book, and also they kind of touch on this in the movie, is the experts were so wrapped up in their science and in their testing and everything else. And I'm not saying they should be advocates, but they just dumped all of this information in front of the jury. And then the jury had to try to sort this out without the benefit of any interaction with the expert. And it was just way too much information, way too complicated. And I think it was fair for the jury when they ultimately said, that they found Grace liable, was just to kind of their eyes glaze over and say, tie, it's a tie for the scientific evidence, or we just can't figure it out. So because somebody was seen dumping, we're going to find liability. So expert testimony is required. I mean, you can usually get out of a case if somebody doesn't have an expert, or if you get them knocked out as being not competent. So you have to have an expert who can explain why there is causation in a particular case. But here, I think the experts, and whether it was Schlichtmann's preparation or the experts themselves, kind of did a disservice to the jury by giving such a dense academic presentation that they forgot that they really had to help this jury reach a conclusion.
Yeah, it's really important that the expert has to lay it out in clear terms, and that the lawyer has the responsibility of ensuring in the selection of the expert and the questioning of the expert that it's digestible. I mean, I wonder if also the jury, it was easier for them to dismiss the case against Beatrice because they let the case against W.R. Grace go forward. So they said, look, we don't know. It's confusing as to Beatrice, but in any event, there's a company, there's enough evidence there. And so the plaintiffs are going to get something, going to get some compensation, as opposed to the plaintiffs walking away empty-handed.
Yeah, I mean, it's rough justice, but I suspect that is probably something that played a role. Again, that notion of a scientific evidence is kind of a tie. So we don't feel comfortable saying, the case is over, we can't figure it out. But because we have this, at least it appears, culpability on behalf of Grace, instead of Beatrice, we don't have anybody that we saw dumping. We're going to keep W.R. Grace and let Beatrice go. And it was definitely, I think, easier for them to do that. These are two big companies. It's confusing. At least one of them is staying to answer for this.
You mentioned settlement before, which, as the film itself makes clear, is a key factor in the way in which the overwhelming majority of civil cases, as well as criminal cases, are resolved. If a case is able to survive through the various stages of motion practice, motion to dismiss, motion for summary judgment, and then all that's left is trial, many cases, most cases will settle, especially cases involving lots of money, because litigation is so unpredictable. Right. And here, even though the defendants, as the film describes on multiple occasions, make overtures or offers to Schlichtmann for not insignificant sum. There's a great scene between Schlichtmann and Robert Duvall while the jury's out, and Robert Duvall kind of opaquely offers him $20 million, and Schlichtmann declines the various settlement offers to the dismay of his partners. Why does Schlichtmann reject these offers, and what do you think of his decisions?
So there are two great scenes, the one you described when they're in the hallway, when the jury is out and Facher puts a 20 down and says, what if there are 6 zeros on that? That's very interesting. And when Schlichtmann said, if you're serious, let's get the decision makers in a room. And Facher says, I'm Mr. Beatrice. I don't have to call anybody. We're like kings moving money around. And that probably was the case for Facher. I mean, on behalf of the company, he probably had an upper limit, probably more than 20 million that he was authorized to offer to resolve the case. Schlichtmann really should have gone to the families. I think the movie kind of glosses over it. I think in some cases he did, but I think there was at least one instance where he didn't go to the families and present the offer. And I don't know that there was an agreement with them. I mean, I think he could have said, well, they want an apology. Money isn't the most important part of this. But I think he definitely should have presented that 20 million, and he definitely should have taken it. So that was interesting. And it's very revealing in the end when, and I'm getting ahead of myself here, after he meets with W.R. Grace and he tells his partners that they were offering $8 million, and William H. Macy is just losing his mind when he hears that Schlichtmann rejected it. And he says, well, would you settle for 10? He said, yes. He says, so let me get this straight. You will settle for an amount they're not going to give us. And Schlichtmann's like, I just feel like there's more. I feel like there's more. And that was even true in the very beginning when they had that very memorable settlement negotiation when Cheeseman made an overture to him and they met at that very nice hotel and they had all this food, and Schlichtmann is clearly ready for a long day of negotiating, roll up our sleeves, and Facher comes in late, of course. I'm sure that was by design. And then Schlichtmann starts off, he's got his partners there and says, we want 25 million after he informs them how much their company's made the previous year. So Cheeseman doesn't have a very good poker face in this movie. I doubt that's actually the case, but he kind of glances over at his partner. They sort of nod at each other like, it's not bad. I mean, Schlichtmann sees this, and so then he immediately starts layering on more demands. And 25 million for a study, and his partners look at him in alarm, like that was not the plan. And 1.5 million for family for 30 years. He just keeps on and on and on and on, which then prompts Facher to have a question, which is, can he keep the pen? He walks out because he accurately assesses that this is not a serious discussion. It should have been, it could have been, but if it was just going to keep going up and up and up, it wasn't a serious negotiation. And he just left. And then that prompted Cheeseman and his team to leave too. One can definitely criticize Schlichtmann's approach here to these settlements. We can talk about the end too, what the family said, but that's why this case, I think, is used in law school a lot, at least the movie, is to say, like, you got to tell your clients if you have a settlement offer.
And the idea about the apology, I mean, I don't know what you think, but apologies don't come. They're rare. I mean, the settlement would be probably structured something along the lines of, we're going to give you X amount of dollars, and they're not going to admit liability. So it's to some extent kind of unrealistic, or no?
It is unrealistic, and it's also a real mismatch in the goals of the lawyer and the client. The client makes it very clear at the beginning. Ann Anderson, I think it is, said she wants somebody to come knock on her door and say, we did this, we didn't mean to, we're very sorry. And then I think it's Affiero is his name, who's lost his son, wants them to clean it up at the end. So there's a real mismatch there in expectations and goals. And I think that that certainly is a criticism that's fair for Schlichtmann, is that, you know, he tells Ann Anderson and I think the family is that, you know, the only way to get an apology is through money. And that's really true. I mean, you don't usually see the public apology. It comes to mind was the lawsuit involving the voting machines recently, where Fox News was accused of making misstatements and they had to actually issue an apology. But it's pretty rare that that happens. So that was just not going to happen here. And Schlichtmann is right that the way that they apologize, if you will, or better said, compensate a victim if they were wrong, is with money.
He sort of forgets that understanding, which he started the film with. The level of the award corresponds to the depth of the apology. I mean, that is the way people speak. That's the language of apology, is money in a large tort suit. But he sort of forgets that in a way, or doesn't think that the apology is large enough, one or the other.
Yeah, the end is really painful because, or near the end when he goes to see the families, because he already feels like he's lost because he didn't get a lot of money for them. But the families feel like he lost because they didn't get an apology and they're not going to clean it up. So that mismatch continues, and it's really, really difficult to watch the families as they're realizing you're getting $300,000, which Schlichtmann has told them how a company apologizes. They're not going to clean it up. They're not going to admit wrongdoing or anything like that. And it's a very difficult scene to watch. And again, it just goes back to, at the outset, not managing the client's expectations well, not saying, you know, look, we're not really the entity to make them clean it up. That would be a governmental entity. But what we can do is get compensation for your loss. That's all we can do. We can't get an apology, things like that. So that was something that was a thread throughout the movie.
Schlichtmann tells them they're going to apologize through the damages award. That's how you'll get your apology. And then all he's able to come up with is a relatively paltry sum of $300,000+ given the magnitude of the loss of their children. So it's like they're not really even apologizing. And if I'm not wrong, Schlichtmann further reduces the firm's fee in the case.
Yeah, they recover the costs, which they really had to. And then they did cut their fee pretty significantly in recognition that they really had not served the clients as well as they should have. And, you know, Ann Anderson says, you told us that they apologized for your money. Do you think that this is an apology, a meaningful apology or whatever? And Schlichtmann says, no. And it is that moment of self-awareness. They show his hand gripping the chair, like how difficult this is for him. And he says, no. And then he apologizes to her and she walks out. It's probably not exactly how it happened, but you can certainly understand her reaction to that and dismay of, you're the one that told us this is how they apologize, and now this is all you have. It was never about money, but if you're telling us this is the one way they apologize, this is not an apology.
Another interesting thing about Ann Anderson, who's played by Kathleen Quinlan, the named plaintiff in the lawsuit, her and some of the other family victims, they are sort of reduced just in the movie to plaintiffs, right? They're not really actors. They get Schlichtmann to take the case. But in fact, the family members, local activists, journalists, had long been engaged in advocacy over the contaminated water in Woburn, including with the city government. Ann Anderson, whose 12-year-old son had died of leukemia, had been one of Woburn's leading advocates. Here, I think there's more to unpack. The film doesn't really talk about the family's role in the advocacy they've been doing. It also suggests that Schlichtmann's lawsuit is what triggered the EPA, the Environmental Protection Agency's investigation, which is what led to the $68 million fine and court-ordered cleanup, as well as the indictment of the W.R. Grace Corporation. But the state investigators have been looking into contamination before Schlichtmann's suit. It had found in 1979, again, well before the lawsuit, that the municipal wells that provided the drinking water to Anderson's neighbor were contaminated with industrial solvent. What do you make of these criticisms of the film its treatment of the victims and the non-inclusion of the various other actors, and sort of the elevation of the role of Schlichtmann as the person who ultimately instituted the change in Woburn.
It's a fair criticism. The book does a much better job of tracing that and talking a lot about that. So it's a fair criticism, but at the same time, I think it just is a mismatch of expectations. This is a movie about lawyers and the process of a trial. It's just about the lawyers. So if you go into this movie expecting this to be a broader look at companies and chemicals and activism and things like that, you're not going to get it. This is very intentionally, the movie at least, not necessarily the book. The movie is a sliver of the book, but it is very intentionally a drama about the lawyers. So the fact that it doesn't focus on that, I think, is just a function of the story that the filmmakers wanted to tell. It's a commentary on using the court system to compensate or victims, or, can you ever do that? Who are these lawyers? Because in the end, I think you have a much more nuanced view of Schlichtmann than you do at the beginning when he's tossing his business card at some guy who just had a car accident, which shouldn't happen, doesn't usually happen. But I think that while that criticism is fair if you're looking for the whole story, it really isn't if you understand, at least my understanding of the movie as opposed to the book, which is very intentionally a drama about these three lawyers and the judge.
I think that's really well put. In a sense, they exclude out the other gradations and aspects of the story because they want to make this a statement about law, the legal system, its aspirations, its shortcomings. And I think it does do that very well. It's kind of interesting. I mean, you could imagine a different film. You could probably imagine a TV miniseries where you have many other characters, because one of the other culprits, I think, in this story is Woburn city officials. First of all, they constructed the wells in an area that were already heavily polluted in the mid-1960s. And then they proved unresponsive when people like Ann Anderson and other advocates were voicing complaints. So that's not the film they chose to make, but you could have a film where there are a lot of other players, right? And you could have the Woburn city officials who are, I don't know if you agree, bore significant responsibility, both in terms of where they put the wells and how they treated the victims when things started to come to light.
I mean, those wells are the link between the contamination and potentially the damage to the plaintiff. So that's absolutely right. And it reminds me of, unfortunately, a more recent example of like Flint, Michigan, where there was lead in the water. And again, its city officials had a lot of responsibility here. And it's really shocking. The movie touches on it. When you read the book, the amount of problems with the water, I mean, people were having skin infections. It smelled, it was discolored. For years that happened. And, the laundry wasn't effective, things like that. So the people in the area that were served by those two wells in particular had complained for years and years and years, and Anderson especially, but all of them. And to think that it would go on for so long with the officials doing somewhat cursory or superficial review of the wells, they'd shut them down temporarily, and then they would just bring them back online and say, yeah, they're fine. It was really pretty shocking. And I think by today's standards, although Flint, Michigan is an unfortunate exception to this rule, I think by today's standards, that just wouldn't happen.
It's a different time, and I guess partly as a result of some of the litigation like this to try to change. One of the other challenges, just quickly, that the film talks about that Schlichtmann has to try to get the evidence, try to get people to cooperate, right? People who have pressure because they work for a company to try to say what really happened. And the center of that is the character played by James Gandolfini. I had forgotten that he was in that role because the film, I think it was like right before Sopranos. So before James Gandolfini kind of hits with Soprano, and he was fantastic in the role of that person who was sort of torn between not wanting to say what happened because of the employment pressures and just feeling an obligation to the community. I thought the film did a great job capturing that.
I thought so too. And I think that James Gandolfini's character probably stood in for a lot of the witnesses. But yeah, other than Jerry Facher, I think that was my favorite character in the movie because his performance was so good and so nuanced. And for what he ultimately became in Tony Soprano, completely different role. He's kind of a quiet family man, and he's humble, and he's really tormented by this. But, he ultimately does the right thing. And 2 points about his character, I'm glad you brought him up. First of all, in the deposition, when Schlichtmann asks him if he ever saw anyone dumping, and he says yes. And then she's going to say, you don't have to answer that. Do you want to take a break? First of all, I doubt that happened because you don't do that in depositions. But that was kind of a funny moment too. And then later on, Schlichtmann goes to his house And I'm thinking, this is an employee of a represented party. I don't think you're supposed to be doing that. So those are a couple of things that if they in fact happened like that, which I rather doubt, were ethically questionable. But yes, his character was really terrific. And like I said, probably stood in for several witnesses. But to see him wanting to, not have people at work angry at him, it's a small town, but then he goes home and he's watching his wife pass around a pitcher of water to his family. And then he goes to see Ann Anderson and he's clearly burdened by his conscience and then comes clean and starts naming names. It's a really, really great character.
He's very different, the character in the film, than Tony Soprano, but you do see a little bit of the same kind of suppressed rage. Now, he acts on it in a very different way in the film, cooperating with the legal process as opposed to what Tony Soprano did.
Right.
You kind of can see the burning in the eyes. I mean, it's a tragic loss of James Gandolfini.
For sure.
Are there any other aspects of the movie that were notable or, where things that maybe the movie left out in order to tell the story or that struck you?
So other things that I think are notable about the movie, just a kind of global comment, is you start off with Schlichtmann very confidently describing the trial process and saying these things about it. So he's the voice at first, but then it switches to Facher as he's teaching these evidence classes at Harvard. Then he's the one who's kind of narrating through his class what trial is supposed to be and how one conducts a trial. So I thought that was very interesting that it really switches. And it was also really interesting, too, that there was a quote from Schlichtmann in the beginning where I think he says something like, you can't take on your client's pain, and if you do, you shouldn't be practicing law. And then that's exactly what he does. And Facher, in contrast, and he's not dealing with devastated families, but he knows that. He never really loses sight of that. But it's just interesting to see it switch from, not that Facher isn't as much a narrator, but it goes from Schlichtmann talking about the purposes of trial to Facher through the evidence classes. So I thought that was really interesting.
Yeah, it's really interesting. It starts with Schlichtmann's perspective on the legal system, but it's really ultimately Facher's that the film leaves us with. Let me play this clip of this colloquy or exchange between Schlichtmann and Facher, which kind of gives a little bit of a dark view about the legal system, including its ability to deliver truth and justice.
What's your take?
They'll say the truth.
The truth. I thought we were talking about a court of law. Come on, you've been around long enough to know that the courtroom isn't a place to look for the truth. You're lucky to find anything here that in any way resembles the truth. You disagree. Since when?
8 kids are dead, Jerry.
Jan, that suit fits you better than the sentimentality. That's not how you made all that money all these years, is it? You want to know when this case stopped being about dead children? The minute you filed the complaint, the minute it entered the justice system. Hey, I know, you like to gamble, like you're a high-stakes gambler, that's your profession. Why don't we test your born-again faith in the righteousness of our courts with a high-stakes gamble?
If that's a settlement offer, Jerry, it's not enough.
That's not what I hear. The IRS telling us they have a lien on any eventual settlement in order to recover over $2.5 million in unpaid taxes. All right. What if I were to add 6 zeros onto that? That's right, that would be, what, $20 million. That would put things in perspective for you, wouldn't it, as far as truth and justice and dead children go?
If you want to talk seriously about a settlement offer, let's get the decision makers together and talk seriously.
The decision makers are here, aren't they? I mean, you're looking at Mr. Beatrice. I mean, I don't have to call anybody to you. It's just you and me. We're like kings. We are kings. Sitting in our castle, deciding important things, deciding the fates of others, and counting money. In our counting room. I'll tell you what, I'll leave this here. I'll go back down the hall to my throne room, and I'll await your decision. Well, if you're really looking for the truth, Jan, look for it where it is, at the bottom of the bottomless pit.
Does the film get it right? I mean, is Facher right again?
Gosh, I feel like I'm coming down much more on Team Facher than I expected to, but Yeah, I mean, I think the film kind of does get it right. And I think that all of the characters recognize that the trial is a corruption of the process. And Facher knows that too. His case stopped being about the truth as soon as you filed a lawsuit. And that's not to say that a lawyer who's seeking the truth and files a lawsuit is wrong. That's the only thing you can do. I think the bigger point is that the system for a case like this is probably not the best vehicle. I don't know what the answer is. It's what we have, but it's not wrong because you have rules of evidence and you have experts and you have jurors who are asked to draw upon their common sense to reach a conclusion, being confronted with a month of very technical expert evidence. So the truth is very difficult to find in a courtroom because of all of these other considerations. So it is a bit too dark in my view, because I do think that the system that we have incentivizes settlement, which I think is a good thing. And there are times when you have to go to trial. You have to vindicate a principle through trial. And in the appropriate case, this probably wasn't the right case. In fact, I'm sure it wasn't. A trial can be the right thing to do. And I defended a few cases at trial for that very reason. And it wasn't that anybody failed. It was just that we really couldn't agree. It was too consequential. And while it may not have been a probing search for the truth, it really was about principle and it was a worthy cause. But to say that a trial is not a pure search for the truth is accurate and fair, I think.
As Thatcher says, right, if you want to look for it, I think, no pun intended, it's at the bottom of a dark well. I mean, and who knows if Schlichtmann had settled for more money, maybe the truth would not have been uncovered, right? There would have been no final determination, but there would have been some approximation of justice in terms of what the system can deliver. And then you do have the other aspect, the EPA investigation, right, which does lead to a significant fine and to the cleanup that's
right. And it doesn't compensate the families, but that really is the better way to deal with a situation like this, terrible as it is to have a company, if they're found culpable, to have them held accountable, punished, and forced to clean it up. And that's what the families wanted. The trial system, court system could not deliver that. So it came in the form of regulators later on, delivering that for them.
One other thing that comes to mind is that some of the difficulties faced by Schlichtmann and some of the tactics perhaps used by his adversaries in the case recall those from some of the other large mass tort litigation at the time. And I'm thinking really of the case against Big Tobacco, where you have some of the same challenges in terms of proving causation, also some of the potentially very harmful effects and large damage awards. So are there any connections that are in the film, either explicit or implicit?
Definitely. And I think the scene that best depicts that is when it's a compilation of Facher from deposing the families when he's trying to do what they did in the Big Tobacco cases, which is sow doubt about causation and try to point to either other environmental factors or lifestyle choices that may have led to the injury. And so we see Facher going through these questions. Do you eat peanut butter? Do you have fillings in your teeth? Do you use hairspray? Eat bacon, pump your own gas, things like that. He's clearly setting that up so that he can try to defend the client by saying these other things contributed to or caused or are so confounding, we can't tell. And that's something that happened a lot in the tobacco cases, where it really is difficult sometimes. I mean, it seems really obvious you smoke, it's going to cause lung cancer. But a lot of folks had other lifestyle choices or environmental factors that could have contributed to their harm. And that's the same approach that was used there.
That's a great point. And I'm thinking it's also interesting in terms of the tobacco cases, which I think are different for various reasons, but where the system does produce some positive outcomes in terms of some of the reforms that grew out of the tobacco litigation on regulation of smoking practices.
I totally agree. I mean, it's very similar type of challenge. And I would suspect the tobacco cases probably had very similar complicated scientific evidence. And it is their job to say that there is a possible alternative explanation. I mean, I would do that in a trial if someone had, say, a soft tissue injury from a slip and fall or something like that, and they're claiming damages because of this. There could be other factors. They may have arthritis. Their medical records may reveal that they injured it playing softball or that they had some history of a joint disease or whatever. It is your job to try to tease out what those other factors may be that could contribute to or cause the harm about which they're complaining.
Even in the film, Riley, he's a bad dude, right? He's a liar. In another situation, it could be maybe someone different, someone who owns a business who is not actually responsible, and there's an effort to attribute the harm to him. So yeah, in this case, he was the bad guy, but the system's there to kind of protect those other individuals, because it's not necessarily the person who had a industry near where the water was contaminated is not necessarily the one who's responsible.
And it is fair, too, that the film, I think, does a pretty good job of highlighting that Facher and Schlichtmann both view this as, oh, we're just deep pockets, that's why you're suing us. It's not because you really have proof that we did something wrong, which was the reason for Schlichtmann's Rule 11 motion. And that certainly is the case sometimes when the federal government, one of the deepest pockets around, and there were some plaintiffs who were opportunistic and thought that they could file a lawsuit and try to get a big check from a defendant from the VA or from whatever government agency it was, because they had deep pockets, and that if they sued, they could extract some sort of settlement. And so it was really important. I mean, especially there, I was defending taxpayer money. I saw myself as protecting it and having to be responsible, and it would have been irresponsible if I didn't at least explore whether there were other reasons that this person was harmed. In the end, if we determined that they were, we compensated them. But part of my job was to examine that. There's nothing wrong with that. And I think Facher's character does that really well in the film.
Let me ask you about that. In addition to settlements often not containing an apology or an admission of guilt, they can often be confidential, which is one way to potentially address the concern that Sidney Pollack, playing the head of W.R. Grace, expressed, that there'll be this kind of shark effect, that if people see us settling with the Woburn victims for this much, everyone else is going to come in. It's going to be a feeding frenzy as you keep the settlements confidential. Unless I'm incorrect, that's not an option with the government. And based on my experience, that the amounts are discoverable.
That's another thumb on the scale. I sort of had the luxury of having other things to concern myself with when I was in the government, which was I was more likely to settle, not for a larger amount, if I really thought that there was culpability or negligence, because it felt like the right thing to do, which sounds kind of corny. But because I was representing the taxpayers, I really wanted to stand in their shoes and try to approximate, if I were to poll them and say, look, this thing happened, what do you think is the right thing to do? Whereas in this circumstance, it's not that I'm not trying to do the right thing, but it's just a very different calculus. Florida has pretty robust sunshine laws where a lot of things involving government agencies has to be out in the open. They have that same pressure of not only the amount being out there may incentivize people to bring lawsuits, but it can also bring questions from the taxpayers of why did you essentially give away that money, which is absolutely fair if you're dealing with public funds to have those questions, but it's a challenge that private companies don't have. Their shareholders may have questions, but it's not going to be the public at large.
So the film focuses on the case brought by the Woburn victims and what happens at the trial and the settlement, but it has a much longer history, including a history after where the film cuts off. There's also a separate history involving Schlichtmann himself. We get a piece of that when he appears before a bankruptcy judge, great cameo by Kathy Bates, asking where all the money went. Can you just talk a little bit about the kind of subsequent litigation?
I don't know if anyone else experienced this watching the film, but I have to say I was a little bit sort of distracted to see Annie Wilkes as a bankruptcy judge. Seeing Kathy Bates there was really something. It's kind of funny now in retrospect. But anyway, yes, there is that. What happened to Schlichtmann after the fact? His partners went their separate ways. The movie depicts that happened. Schlichtmann went bankrupt. He had virtually nothing to his name. It took him years to rebuild that. So that's his story. But then the case, it went on for a long time. There was an appeal and a new trial. Grace, I believe, sued their insurer for failing to defend them. So there was a lot of litigation that continued on after the fact. But for the purposes of this movie, it makes sense that it was just this snapshot in time of just this trial.
And some of the subsequent litigation involved issues over the disclosure, non-disclosure of documents to the plaintiffs, right?
Right. I believe there is evidence that Riley had commissioned a study or gotten a report that suggested that there was some contamination. I don't remember exactly how it was that was not turned over. But yeah, there was some litigation over that. I think there was also litigation, if I'm not mistaken, over the extremely dense and complicated questions that the judge posed to the jury after the liability phase, which were just almost incomprehensible and inevitably going to lead to confusion. I think that was also part of the subsequent litigation.
Yeah. Additionally, there was litigation by Riley himself. The former owner, John Riley, of the Woburn Tannery, sued Jonathan Harr and Random House, the publisher, for his depiction in the book.
Right.
Yeah, a lot of satellite litigation.
Sure. And I can understand why Riley would not be happy about his portrayal in the movie or in the book. It is definitely not flattering. Yeah, so it had many, many lives after this.
In his defense in the movie, the sort of one thing it said is, look, this is a family business. We've stayed here. We employ people in the community. Fair enough, but that doesn't outweigh dumping carcinogenic toxins in the drinking water. So actually does not come off well.
He does not. And then you have, James Gandolfini's character saying we were told to clean it up and haul it away after the litigation had started, I believe, which is a problem.
Big problem. Jen, it's been so great to talk to you about this movie and share your expertise as a litigator with decades of experience in civil litigation on the private sector and the government, and roots also in Boston, and just to reconnect again after our clerkship in Boston with Judge Lynn. So it's wonderful to have you on the podcast, and thanks again for joining.
I'm really, really grateful that you asked me, and it was a lot of fun. It's great to talk to you again, and it's really a very interesting movie to talk about. So I enjoyed doing a deep dive with you.